welcome to the Deep Dive, the place where we try to cut through the noise and get you the essential knowledge fast. And today we're talking about the creator economy. Specifically, we're focusing on what is probably the most fundamental, most intimate, and frankly, commercially valuable tool any audio creator has. We're talking about your voice. If you're a podcaster, a voiceover artist, anyone who makes a living speaking, your voice isn't just, air moving. It's your commercial signature. It's your brand. But here's the huge and kind of legally terrifying question that's popping up right now. With AI voice cloning getting so shockingly good, who actually owns the IP of that sound?
And that tension, I mean, that's the whole ballgame right there. The tension between your voice as personal identity and your voice as a commercial asset. It's precisely why we've pulled this stack of sources. Our mission for this deep dive is to basically shortcut your understanding of this. We're going to dissect that intersection of traditional IP law, identity rights, and the contracts you have to have. We're essentially trying to give you a handbook for how to protect your vocal self in the age of AI.
Okay, let's unpack this, because the first thing that jumps out from the material is it's just fundamentally counterintuitive. It surprises so many creators. If my voice is my brand, I just assume it's protected, right? But the shocking truth is that the sound of your voice itself, it's not protected by traditional copyright law. Why is that the place we have to start?
It's so crucial because it immediately shows you the limitations of our current legal system. Copyright, which is federal law, it protects works that are fixed in a tangible medium.
Like a file.
Exactly. Think of it as protecting the container. It protects the recording of your performance, the actual MP3 or WAV file of your show. It protects the script you wrote. But here's the critical limitation. Copyright doesn't protect ideas or styles. It doesn't protect those unique, unscripted vocal characteristics that make your voice recognizable.
My cadence, the tone.
Your specific cadence, that gravelly tone you might have, your speed of delivery, all of it. Since those things are just inherent to you, they aren't fixed in the same way a document is.
So wait, if a company were to record a perfect imitation of my voice, they haven't copied my MP3 file, so they haven't violated my copyright.
That's it, exactly.
Yeah.
You own the copyright to your original recording, sure, but that does not automatically give you control over every future imitation or synthesis of your vocal style.
Wow.
And that leaves this gigantic legal gap for any creator whose main asset is their sound. And it's a gap that AI is rapidly driving a truck through.
Okay, so we've established copyright protects the file, the performance, not the identity behind the voice. When copyright just stops, what legal tool steps in to protect me from having my identity, commercially exploited?
That's where we have to switch frameworks entirely. And this is where it gets really interesting.
Yeah.
If copyright is about the work, the right of publicity, or ROP, is about the person.
Okay.
And this is a state-based right. It's not federal. It protects an individual's name, their likeness, and this is key other elements of their identity. And courts have explicitly said that includes their voice.
And it's all about unauthorized commercial use, right?
That's the core principle. It's about the commercial value in your recognizable persona. If you've built a brand, your voice is an engine of commerce. ROP exists to make sure that you, and only you, can control and profit from that.
And the sources gave us that landmark case that really cemented this for voices, the Bette Midler v. Ford Motor Co. case from '88. I mean, that's 3.5 decades old, but it still sets the standard, doesn't it?
It absolutely does. And it's a great example of the principle at stake here. Ford hired a sound-alike to sing one of Midler's songs for a car ad, specifically because they couldn't hire Midler herself.
And the sound-alike was really good.
So good that listeners thought it actually was her. And the court held that imitating a celebrity's voice for commercial gain without permission was misappropriation of identity.
What's so fascinating there is that the court ruled that simply imitating the voice, even without using any of her copyrighted recordings, that was the violation.
Yes, that's the powerful precedent. It proves the voice's identity. The court basically said that when a distinctive voice is deliberately imitated to sell a product, it's like forging their signature. That decision really paved the way for treating the voice as a legally protected part of your personal identity.
Okay, that sounds great on paper, but if I'm a podcaster with a national or even an international audience, I can't just rely on a 1988 California case, can I? This is where we hit what the sources called the patchwork problem.
And that is the major catch. It's critical for every creator to get this. Because ROP is state-based, protection varies wildly across the country.
Right.
I mean, think about it. Copyright is federal. It's governed by Congress. But privacy and identity rights has always been left to the states.
Hmm.
So what this means for you, the creator, is that the strength of your protection depends on where you live, where the person exploiting your voice lives, even where the content is consumed. States like California, where that Midler case happened, and New York, they offer very strong protections for voice and likeness.
But what if I'm a creator broadcasting from a state that's, less focused on celebrities, like Texas, or a state with a weaker, maybe no explicit law for this?
Then you are almost nakedly vulnerable.
Wow.
Other states provide limited, or sometimes zero, explicit rights to control the commercial use of your voice. So if an exploiter operates just in a state with weak Roe P, your ability to control your brand, which is your voice, it's severely compromised.
So it's just this confusing state-by-state calculation.
It is. It creates so much legal uncertainty.
Okay, so let's step back. We have a statutory gap because copyright is too narrow. And we have this jurisdictional gap because identity protection is basically a state-by-state lottery. This seems like a perfect storm, and it leads us directly to that third essential layer of protection you mentioned, contracts.
Precisely. This is where you stop relying on the government and you start relying on, well, legal self-defense. Contract law is the great equalizer here. It lets you explicitly define the boundaries that the laws just fail to establish clearly. You're proactively filling in those holes yourself.
So when you sign a media agreement or a production contract or even a sponsorship deal,
those documents have to be granular. They must specify who owns the master recordings, yes, distribution rights, sure. But most critically now, they must define the ownership and control of the digital likeness of your voice.
So we're not just talking about today, we're talking about anticipating future tech. It's not enough to say, the producer can't use my voice for other projects. You have to define what the future digital version of your voice can and can't do.
Absolutely. Without clear, forward-looking clauses on this, disputes are. They're just inevitable. Think about the risk. A producer, a platform, an old sponsor might use your voice way beyond what you intended, and the only thing protecting you is the language you put on that paper.
Okay, hang on. I need a specific hypothetical here because this is where the money is. Let's say a platform has archived my last 5 years of deep dives. They own the distribution rights to them.
Pretty standard.
Now, AI is advanced enough to ingest those hours and instantly generate a new 30-second ad script, narrated by my perfect digital replica. Selling a product I absolutely hate.
That scenario is not just possible, it's happening right now, or it's about to.
So what can I do?
If the platform does that, your strongest legal defense is a claim of breach of contract. But, and this is a huge but, only if your initial agreement clearly limits or outright prohibits using your voice archives for creating new generative AI content.
And if that contract is silent on AI, which, most 5-year-old contracts probably are.
Then you're left scrambling. You're trying to rely on that patchy right of publicity, which might not even be strong in your state.
It feels like I've just signed away my digital soul without knowing it.
That is the fear, and it is legally founded. If the contract is silent, you've potentially granted a broad license to use your voice data. The producer can just argue they're using the assets they already own, your archives, to create a new work. And you're left fighting this uphill battle, relying on a state law that was designed for celebrity lookalikes, not machine learning.
Okay, and this is where it gets really interesting, because we have to talk about the tech itself. It's accelerating so much faster than the law. AI voice cloning, it's not that choppy robotic voice from a decade ago. It is terrifyingly good.
The rapid advance of AI has it's demolished the old standard. Modern voice cloning tools, they need an astonishingly small amount of source audio, sometimes just a few minutes.
Few minutes?
Yeah, and with that, they can create what the sources are calling near-perfect replicas. We're talking about synthesizing your unique speech patterns, your breath sounds, your tone, your specific emotional cadence.
So it's not just a sound-alike in a studio anymore, like in the Midler case. This is a synthetic performance that is, virtually indistinguishable from the human original. What are the practical risks creators are facing right now, beyond just an unauthorized mattress ad?
The risks are layered. They move from the purely commercial to the deeply ethical and, critically, the erosion of trust. Commercially, sure, if your voice is cloned to narrate competing content or endorse products you'd never touch, your brand value is deleted. Legally, that hits Roe P and unfair competition laws.
But there's a bigger risk, right?
The more significant risk, I think, especially for podcasters who rely on authenticity, is the breakdown of the relationship with the audience. If your listeners can't tell if it's really you or an AI proxy, the value of listening to a human just diminishes.
It undermines the whole creator economy.
It threatens the very authenticity that defines it,
Hmm.
and it allows for malicious deepfakes, using your voice to spread misinformation or say things that destroy your reputation, and then you have to prove a negative. I didn't actually say that.
And that really gets back to that core tension we identified at the start. My voice is both creative output and personal identity. But the bottom line from these sources seems to be that traditional IP law offers, well, limited, geographically varied, and often outdated protection. So safeguarding your voice becomes a matter of aggressive contractual ownership, not just artistry that's protected by the law. Okay, so let's review the key takeaways we've distilled from all this. For our listener, what are the three main tools available for protection?
Right, it's like a three-legged stool of vocal property protection. First, you have copyright.
Yeah.
That protects the fixed recording itself. That's the easy part, kind of the baseline. Second, you've got the right of publicity, which protects your identity and its commercial use, the recognition factor. But you have to remember all those geographical limitations we talked about,
Patchwork.
the patchwork. And third, and this is the most critical one in the AI era, contracts. They are your personalized legal insurance. They're designed to fill all the gaps left by the first two. You can't rely on precedent anymore. You have to rely on negotiation.
So until clear national frameworks emerge, and they will, that's going to be slow, what are the specific actionable steps a creator should take, like starting today?
Okay, it boils down to three proactive necessities. 1, keep registering copyrights in your recordings consistently. That's your basic shield. 2, and this is non-negotiable, you must demand and include explicit voice ownership and AI use clauses in every single contract you sign. Define what your digital likeness is and limit its use, strictly.
Don't leave the use of your voice archives for model training up for interpretation.
Do not. And third, you have to be ready to assert your right of publicity immediately when unauthorized commercial use happens. Your speed in sending cease and desist letters. It often determines the strength of your defense, especially in those stronger ROP states.
This isn't just about protecting a file anymore. It's about protecting you, the person, and your career.
Absolutely. And as this AI technology keeps advancing, we're all left watching this critical legal threshold that the courts are going to be forced to define. If the replica is near perfect, well, what level of specific vocal characteristics, pitch, cadence, tone constitutes a legally actionable breach of identity?
Where's the line?
Exactly. The law has to decide where imitation ends and identity violation begins, especially when the technology makes near perfection the standard.
Yeah.
That shifting line, that's the next frontier of vocal property that we all have to watch very, very closely.